So, why don't we get started? We have a great topic today. It's so important as part of our career planning, and it's something that's often overlooked or weighted, or it happens at a time that we're not in a great position to negotiate. So, I'm really thrilled that Kathy has offered to speak to us about this today. And I welcome all of you for attending. Kathy, I'm going to let you introduce yourself and how this whole topic came about.
Okay, thanks, Deborah. Hi, I'm Kathy Charlton. I'm Harvard MBA class of 1999. I'm actually only going to speak a little and intro our interviewer and our guest. The idea for the webinar came out of my own experiences of job loss and negotiating severance, and also having a lot of friends, colleagues, former colleagues when things happened and after I got closure, saying, how did you know how to do that? How did you know where to get a lawyer, et cetera, et cetera? So I went to Heather Meyer, who I know is in, and I proposed this idea. I thought if that many people are asking me what to do, this has got to be pretty common that people don't know how to run when this happens. Our interviewer today, we're very lucky to have Joy Batra, and Joy's a Harvard JD MBA. She has a range of really fascinating experiences that span banking, law, film, and publishing. And she's the author of a book called The Freelance Mindset. So, again, The Freelance Mindset, I'll do a little plug for Joy. And then our special guest is Jim Thayer. Jim has practiced law for over 25 years, specializing in labor and employment. He is a partner at the New York City-based law firm of Gordon and Thayer. He's licensed to practice in New York State and also in New Jersey. And I had the personal privilege of having Jim represent me in two successful negotiations over the last decade. And I invited him to share his background and his expertise with us today. And I'm going to turn it over to Joy. Thanks.
Amazing. Thank you, Kathy. Thank you, everyone, for being here. This is not the most chipper topic, but the reason that I'm really excited about it is that school teaches you how to get a job, but nobody teaches you how to lose one. So that's what we're going to do today. And the moment that you need to know how to lose a job, it's already kind of a little too late. You're in the middle of, a crisis situation, shall we say. So I think what we're going to do today is just come through and look at all the best practices for how to plan ahead for an unexpected ending if one comes your way, and how you can be in the best position to have your finances and your dignity intact. So, as a friendly lawyer, I have to give the necessary disclaimer that today's webinar is just for educational purposes only. We will be using some version of Chatham House rules, so please try to keep any information that somebody happens to share in the chat confidential. But this is educational only, and if you have specific questions about your circumstances and you need a lawyer, please go consult a lawyer for yourself. So, Jim, welcome. Is there anything, first of all, that you would like to add to our disclaimer before we start asking you many questions?
No, that pretty much does it, Joy. It's obviously there's a lot of legal topics that are going to come up today, and we're going to talk in general about those. And again, that's for the informational purposes and to introduce the subjects. But as with any legal issue that anyone becomes involved with, they're very fact intensive. And so if you feel that something is important that you need to discuss, you got to get to see some counsel about it and get some personal advice about that. Legal advice. This is not legal advice here. You need to see an attorney about that.
Absolutely. So great. So to kick us off, Jim, would you be able to share with us a little bit about your practice and the kinds of workplace issues and clients that you tend to work with most often?
Yeah, sure. Gordon and Thayer, which has had some prior iterations, has been around since the 40s. It was started by Murray Gordon. Ken Gordon is the senior partner now. It was his father. And so we have a long history of fighting for civil rights and individual employment rights and labor rights throughout the 50s and the 60s into the 70s and the 80s. And now our current practice hasn't changed much. We still represent individual employees in individual employment rights cases. We have some small employers. We also counsel in the context of their relationships with their employees. We handle every type of discrimination, whether it be gender discrimination, sexual harassment, race discrimination, religious discrimination, whistleblower retaliation issues. I do a very specialized area of whistleblower law where I practice before the Department of Justice, representing FBI employees, both agents and civilians, when they blow the whistle on misconduct or violations of law, rule, or regulation. So our history and the substance of what we do is very dedicated to employees and the workplace, and helping small employers too, because small employers need guidance and how to manage these relationships with their employees for the benefit of everyone and everyone in labor.
Amazing. So you can't open a newspaper or a social media site without seeing the word layoff or its corollary RIF, which is reduction in force. So my first question to you is that we all hear this word or phrase at will employment all the times. But in practical terms, from your perspective, what does at will employment actually mean? And what rights, if any, do employees still have in an at will world?
Yeah. So at-will employment is the underpinning for virtually all employment that you're going to run into, in particular in the private sector in the United States. Virtually every jurisdiction is an at-will jurisdiction. And that means that in the absence of a contract or in the absence of a labor agreement, a collective bargaining agreement, if you're a member of a union, that you're an employee at will and you can leave for any reason at any time, and an employer can decide to separate from you and fire and terminate your employment for any reason that isn't a legally prescribed reason, that isn't a violation of law. For instance, the classic versions that most people are familiar with that come out of federal law in Title VII. You can't terminate or discriminate against someone based on their race or their gender, national origin, religion, and many, many other categories. And states have many categories beyond that, genetic information, marital status in New York State. So although employees are at will and they can be let go for any reason at any time, they still have rights with regard to what's happening. They can't be let go for an improper reason. And that's something to be very mindful of, and it's a very important factor.
That's great. So, why don't we come back to this idea of an improper reason? But let's assume first that it's not an improper reason and it is just a standard garden variety layoff. Um, in those cases, what does a typical severance package look like in your experience? And what are the parts that are usually negotiable and what's more or less take it or leave it?
Well, you're talking about reductions in force, and that's in the absence of some type of improper conduct that's surrounding it, which I'm sure we'll get to later. And on the one hand, there's nothing that's typical, but what we often see is that for non-managers, you're looking for a week or two per year of service. For managers, you might be looking at 2 to 4 weeks per year of service. And for executives, somewhere between 3 to 6 months, depending on the length of the service, maybe up to a year. And again, this is in complete absence of some extraneous factors that might surround the separation that might provide some type of different leverage for negotiation. And also, that is the one thing to be mindful of, is that there's no statute or law that requires this, apart from one thing would be the WARN Act, which does require that in certain instances. So if the WARN Act applies, then there's certain severance that is required under that. But those are fairly rare instances in the individual sector. Nonetheless, you should be mindful of it and explore it. But failing that, there is no statutory requirement that you get a certain amount of severance. Now, many employers have a policy of providing severance, and that's a good thing to know, because that will and should be the starting point. And it's very hard for an employer to say, well, you're not entitled to that when that is their policy. So that's a general idea of where the severance comes. Now, when you talk about negotiation, what's negotiable? Everything is. Everything in the severance agreement is technically negotiable. It really depends on how much leverage you have. And if you don't have a lot of leverage, then you're not going to be able to negotiate too much. That's fundamental, and I think it's something everybody understands. Yeah.
Yeah, so compensation is probably the area where most of the negotiating time is spent. After compensation, what are kind of like the top couple of areas where people spend a lot of time negotiating?
Well, for the employee, you're obviously the consideration of the compensation, right? That's the most important factor. But you're also going to want to look at things like you're going to be mindful of the release they're looking for you to sign. These releases, that's very often what the employer is getting out of the separation agreement. And you'll oftentimes see the separation agreement be called separation agreement and general release agreement. It's right up there at the top. This is what the employer is looking for. You need to be mindful of that. And that's a key point of negotiation for both the employer and the employee. The employer is looking for something that's going to be very broad and cover a lot of claims that might otherwise come up. And the employee, as an employee, you're going to want to try to narrow that because you're not going to want to waive everything under the sun. There are certainly some things that you're going to be willing to waive that are related specifically to your employment. And that's something to be very mindful of. In addition, you're going to want to be extremely mindful of whether or not there are non-competes in there, whether or not there's non-solicitation agreements or clauses in there, or and the nature of the confidentiality provisions that might be present, right? These may well affect your ability to gain future employment. Another key factor to be thinking about here with regard to those is you may have signed agreements that already have non-competes and non-solicitations in them, and you need to know about them. So when you are involved in this process, you need to be looking at what they're giving you in terms of the agreement, but also asking what other agreements are in play. And any good attorney that you go see is going to ask you that question. Because I have to ask it all the time. I need to see those. I need to see what you're bound by now, and that's going to be a key to negotiating that going forward.
Yeah, so non-compete clauses have been in the news a lot in the last year, and we've seen kind of some indication they might not be enforceable, some indication that they might be. What are you seeing in practice, especially when it comes to separation agreements? And what do you think people should be asking themselves about the scope of a non-compete if it's proposed, like the industry, geography, time, et cetera, before they sign?
Right. So look, in order to be enforceable, non-compete agreements have to be reasonable in scope in New York State. Each state will have some different interpretation and application of how enforceable a non-compete will be. In New York State, it has to be reasonable in scope in terms of time and geography. And so what's deemed generally reasonable, 6 months to a year in terms of time, meaning you're not able to go to a competitor during that 6 month to a year period, or you're not able to solicit old clients, which can be a very, very important factor, especially for many executives who build up relationships over decades. And so now they're in a situation where they may not be able to talk to some of those people and solicit some of that business for 6 months or a year, and that puts them behind in the next phase of their career. So it's got to be reasonable in scope. I have had cases where I've seen agreements and they've been signed by the employment agreements, which include non-competes that are worldwide or nationwide, and those are clearly overly broad in terms of geography. In the absence, I suppose, of some very, very, specialized circumstances that I've never seen come up. And that would be unenforceable. Nonetheless, they exist. And now you put the employee is going to be in a situation where here it is, it's existing, and they may be fighting that off later on down the road, trying to figure out what to do. If you can negotiate that provision in terms of the separation agreement, that's optimal. The optimal way to deal with this is to deal with this in the separation agreement, and because what you're going to see in your separation agreements most of the time is that they're going to refer to all of the non-competes and all of the non-solicitation agreements that you may have otherwise signed. So if you signed an employment agreement back in 1999, you've been there for 25 years, and there's a non-solicitation or non-compete in there, you're bound by that now, and you will be going through the termination. So you got to find some way to deal with that. And I've had clients who have had to try to deal with those issues because they want to go on to the next phase and be able to, use their contacts, build up a business for the next phase, whatever it might be. And so it's a very important factor.
Setting yourself up for the future is kind of the most challenging and exciting part of this. I think now, assuming in this world that we're in, just for, these next couple of moments where there was no improper treatment and no discrimination potentially, just a standard layoff or, closing, what are some of the variables or levers that somebody has in order to negotiate their compensation? I'm guessing, I imagine it might be kind of the length of their relationship or the length of service. I know you mentioned that the company might have a policy, but is there anything else before you start getting to this idea of unfair treatment that somebody could use to increase the package?
Right. Yeah. In the absence of some of those extraneous factors that we'll get to in a little while and talk more specifically about, your leverage is going to be fairly low. There are things, of course, that the employer wants. And again, the main thing is they want that general release. They want to buy that comfort for themselves that you're not going to come back at them with some sort of lawsuit, that this is going to end, the separation will be complete and they will go their way and you'll go your way. And so there is value to that. And then the question is, how much value is it? Ordinarily, the employer has already set the market for that when they make an offer of whatever it might be, 2 months, 3 months, and that's what they're offering, and that's what they're valuing that general release as. There may be there may be some non-discriminatory factors that come into play. They'd be fairly unique. For instance, they may be asking, I suppose, depending on the nature of your job, they might want you to complete some deals that are in play, so that you'll have some leverage there because obviously that's a benefit to the employer as well as you. But in the absence of that, the main leverage you have is they want you to sign this agreement. And so your leverage is going to be fairly low. It's going to be very hard to negotiate, to up the consideration, up the severance that seek 12 months or a year when they're offering 3. Right? It gets very hard to make that argument, and you're going to have to be quite creative and realize that you just may not have the leverage to get to a place that you want to be, in the absence of, as we talked about, some other types of claims.
Yes, absolutely. Um, so I see one comment from Kathy in the chat, and before we move on to the leverage and the potential unfair treatment, when you have a standard non-compete, are there any other ways that you can work on to narrow this? For example, stating that certain companies or parties are off limits during the non-compete, or making
Yeah.
it tighter in scope?
Yeah, that's a way to potentially try to, because you want to address this, right? So you're looking to try to narrow the scope of that non-compete, maybe get yourself a short list of clients that they come to some type of agreement with the employer about the clients that they're willing to let you talk to and solicit business from, as opposed to all the clients. There's these top 10, these are the best, these are my best contacts. I want to be able to talk to them. You want, whatever you're going to do, you really want to you want to address it directly, head on, and get it in writing, because otherwise you leave yourself open and exposed to claims by the employer that you violated this agreement, and if you violated the severance agreement and or the non-compete that might underlie that severance agreement, you can void the agreement, and you're subject to clawing back the whatever severance payments they've made, and a lot of trouble, and potentially other damages underneath. So this is something to take very seriously. And again, it goes back to the leverage you have. What can you negotiate? If you've got reasonable parties, you're hopefully going to be able to negotiate something. We have varying levels of success in being able to negotiate some of these provisions. Sometimes we get employers who are, from their point of view, they're like, no, it was signed, it's in play, it's going to be for a year, that's the way it's going to be. And you can't move them off the position. And that can be a real problem if there's an underlying agreement where the non-compete already exists. It's one thing to have the non-compete not exist, and then they want to stick it in this severance agreement, right? And then you don't sign it, you go your own way. I won't take the 6 months, but I'm going to go conduct my business with all the people I've worked with. And could well be a good result. The big problem is often we see very often. I have a couple of cases that I've just worked on recently where there were underlying non-competes, and we're trying to figure out how do we find a path through for our client so that they'll be able to conduct business, have that career continue, and not be on essentially some sort of garden leave for 6 months or a year while they wait for that to elapse.
Yeah, and that's a really creative solution that I hadn't heard of before, but absolutely, you can turn down the offer and just go conduct your business too. In this case,
Be mindful of making sure that there isn't an underlying non-compete,
yes.
right? Because that's something people, again, the example of someone who signed the employment agreement in 1999, and you don't remember what's in it. You've got to look at it because it's there and it's binding, and that is just as binding as whatever you might sign now.
Yeah, and that's the main place it would be, the employment agreement. Uh,
And employment agreements, but also many employers have you sign separate specific non-competes and non-solicitation agreements because they want it way out there. They don't want anyone making an argument, well, I didn't know about it, or some type of undue influence argument, or you hid the provision in deeply in it, and I didn't. Not that that might work well, but they're making every effort to put that right out front, so everybody knows it's open and notorious. You're bound by this. You can't say you didn't know about it. That kind of thing. So you definitely got to address those issues.
Yep. Amazing. Okay, so now let's move on to the next scenario, which is the situation where somebody is let go, and that employee thinks that there has been some sort of unfair treatment or discrimination or improper behavior. So I think my first question, just to lay the groundwork, is from a legal perspective, what kinds of behavior are actually protected, and what's just bad management but not unlawful?
Right. Look, the adverse actions that might otherwise be taken, if they're taken for an improper reason, then they are actionable. Now, we talked a little bit about that at the beginning. There are various laws in the state of New York. There is the New York City human rights law was a very robust human rights law and one of the best in the country. There's a state division of human rights law, and there's New York labor law. But those laws provide many protections that a lot of people are familiar with. Again, protections based on gender. You can't be treated improperly or unfavorably because of your gender or your sexual orientation or your race or your national origin or your religion, and on and on. There's federal laws that similarly protect that. And also there's the Age Discrimination in Employment Act and the Disability Acts. There's the Pregnancy Discrimination Act. So there are many protected categories that protect employees. And if actions are taken, if there are adverse employment actions, for instance, if you are transferred based on one of those protected categories, well, that would be an actionable adverse action, assuming the transfer was unfavorable. You're sent to Alaska, and because for some reason they don't like, your Irish national origin or something like that. That would be actionable. If, on the other hand, employers are allowed to mismanage as much as they want, as long as they're not doing it for an improper reason. So if you have a manager who just makes ridiculously silly and foolish decisions about how to use you, and they're not based on some improper reason, then those things won't be actionable. Similarly, there could be rude behavior. If that rude behavior is in the context of some protected classification or category, then it becomes actionable and you're protected. If that rude behavior is just rude, because some people are rude, then you're not in a situation where these laws are going to protect you. There may be workplace violence laws, and there's policies that many employers have with regard to workplace violence, and you should explore them. And you should report this conduct always internally, because putting the employer on notice that this stuff is going on is very important. It may turn out that some of this isn't actionable. Nonetheless, you put them on notice that this conduct is improper, and it also could develop into something that has, you never know. In the beginning, it doesn't seem to be actionable, but later on, it becomes clear that something is going on here. It starts to feel bad.
First time something happens, you don't know if it's a pattern, you don't know why it's happening, but sometimes the employee will just get that feeling that something is wrong. So reporting is a great first step. I think another question that comes up a lot is, when should the employee start documenting what's happening, and what does good documentation look like?
Well, so it really depends on the situation. I think that documentation can always help, and when someone comes into the office here, we're always very happy to see that if they've done some documentation at all. It doesn't always happen, and part of it is, I think, it's kind of the frog in the boiling water type of parable. Everybody's familiar with that. The water is warm until it gets hotter and hotter and hotter, and suddenly it's boiling. And it's a similar situation. Stuff starts to happen. Maybe you just let it roll off your back, and you think, oh, this can't be that. And then suddenly, before you know it, you're like, whoa, things have gone sideways here. I think the thing to do in this instance, and something I counsel employees to do, is look, if your gut is telling you something doesn't feel right, it might not. And there might be really something going on here. Start taking some notes. Keep a notebook of sorts, and hopefully that'll be a notebook that's not a loose leaf binder where you can take the pages in and out, but rather a notebook that's bound, so that you can see things happening chronologically and you can't remove pages, and record what's going on. This can help you in two ways, right? You may well find that something really bad is happening here, but can also provide you perspective for a review of what's going on, and you'll look at it, and you'll be able to say, all right, well, it turns out that this wasn't what I thought it was going to be. And that's a good thing to know too. It's very productive. But on the other hand, as all too often, I suppose, is the case, you're involved in a situation where there are lots of bad things happening and they escalate. And now you've got a long history of it. And you should try to take those notes and make them contemporaneous. So it's every day or every other day, so that there's a lot of value to contemporaneous notes. I've had cases which have hinged upon contemporaneous notes, many before the Department of Justice, where those have been pivotal in finding liability decisions. And so I can't stress enough how important that is, because people look at it and say, well, they wrote it down at that day. There's something to this. This isn't a manufactured situation. To that point, to the extent you're able to timestamp these notes, and there's many ways to do that now with emails or some electronic metadata in electronic files, that's important too. But the documentation for your own personal purposes, that's I think extremely important to just get started, again, because it can help you do two things. One, prepare if there really is something bad that's happening, and you'll be able to come into an attorney like our office or some other attorney, and it'll assist you in telling the story, which is always the most important part. Or you'll look at the situation and it'll give you the opportunity and the perspective to look and say, all right, so it turned out it wasn't so bad. Everything's okay, and there's some comfort in that too. In terms of documentation, other things, if things start to go sideways and you really know something's going on, you're going to want to start to preserve things like email and text messages. I think because of the nature of communication these days, they become very important, and they can be very difficult to get discovery. Not impossible, but there's all kinds, and also other social media. So if you can preserve those things, that's important too. You must be mindful of the employer's policies with regard to these things, though. So you got to be careful about removing things from the workplace that shouldn't be removed, because you'll just jam yourself up with some misconduct there. You don't want to take emails away that shouldn't be taken. So you got to be very careful about that. But nonetheless, try to preserve as much as you can.
So, tactically, how might that work in terms of taking emails or screenshots? I imagine most companies have some sort of policy around what information they own and what you can take and can't take, and it could lead to trouble down the line. What is a best practice for using email if there is a meaningful email that you need to preserve for later?
I think, look, the first thing you've got to look at is the employer practice and see what you're permitted to do. Failing, as long as you're not going to run afoul of some practice, and look, you got to be mindful of what confidential information might be in the email too, and so this are all factors considered. If you're worried about such a thing, I think it's time to talk to an attorney and get some counsel on this specific issue. Trying to give this type of advice in the abstract is dangerous. The one thing you don't want to do in a situation where you feel like you're in jeopardy is create more jeopardy for yourself. So that's the moment when you're starting to look at these things and say, oh, this email doesn't look good, is go see an attorney and tell that story to the attorney, and you and he or she can collaborate on how best to proceed.
That's one of the things that people, poor frogs in the boiling water, don't know until it's too late. But now that we're here today, it's really helpful to know that once you start to worry, that's a good time to start getting external advice just for a sanity check for best practices. And so you can set yourself up and prepare to navigate whatever is coming kind of the best way possible. I think a lot of people have a temptation to represent themselves, but in this moment, I think getting that external guidance can be really useful. So let's shift gears a little bit from improper discrimination or protected characteristics to the world in which somebody is fired unexpectedly or for cause. So, different scenario. If someone is let go for cause, what rights do they still have, and how is it different from a layoff?
Well, I mean, when you mean a layoff, meaning a reduction in force, right? If you're let go for cause, the question is, what was the cause? I think, and then we want to talk about the factors that surround that. If you're let go for cause, I think the thing you want to do is seek counsel, and probably right away, because and we have people who come into the office all the time, and we we start to dig into what's happened and what's been going on for the past 6 months, past year, past 2 years, and many times, not always, we see, oh, there's something else at play here. And that's what's key in this situation, right? Is there something else going on? Uh, you know, is the alleged misconduct, first, is there any basis to it? And oftentimes people say, no, this was not my fault. If there is a basis to it, then you're going to have to deal with that fact. Doesn't mean that there isn't something else going on too, and this was a convenient excuse. And nonetheless, this person was treated differently because someone else wouldn't have been let go for this particular infraction, but this person was let go, and why was that? But those are all the factors that surround that. So the rights you have all stem from the facts that surround each case, which is why it's so important that when this happens, that you see counsel and you have an opportunity to get advice about what's going on and see, what if any rights are in play here. Now, having said that, just to follow up, even when you're let go for cause, you're very often going to be faced with a separation agreement, which is all what we're talking about today. And that's, you're going to, the same fundamental principles that are at play for RIF separation agreements are at play for these agreements too. You'll have to negotiate it, and your negotiation leverage is what it is based, in this case, if it's for cause, it might be less, but that's something we have to figure out.
That's great. And it leads right into my next question, which is how can engaging legal counsel, regardless of which of the different, termination scenarios you're dealing with, how can the legal counsel help not just with the money and claims, but also with softer issues like managing your reputation and your narrative and setting you up for success in your next role?
Well, one of the, in terms of a separation agreement, one of the key things that you're looking to do often from the employee's perspective is to manage how the employer is going to talk about you, right? And what they're going to say. And that's why we often try to get mutuality into the non-disparagement clauses. Non-disparagement clauses are something that employers routinely put in in the separation agreements. They want to know that you are promising not to say anything bad whatsoever about the employer. And these clauses, as they're drafted by the employers, are often extraordinarily broad, meaning you're going to, and it's something to be very mindful of for you as the employee. And one of the reasons I think you always want to get counsel and and talk to an attorney about the nature of the clause, because the class of individuals you could be releasing against could be so broad you couldn't possibly know who they all are. Every employee by ABC Corporation, you're promising not to say anything, a cross word about any of them, and that's you can't possibly know who all those employees are. And so you're going to need to try to negotiate that in a way that makes it reasonable for you to abide by. Now, it may not surprise most people, but the employers aren't often putting in mutual non-disparagement clauses. And you need some comfort here. You need to know what the employer is going to say about you. And we spend some time, and sometimes a lot of time, trying to negotiate that. And that can make it easier for you in the next phases. You'll have some comfort in knowing that when they call ABC Corp to see that they're going to say X, Y, and Z. Oftentimes that may be something as simple as John or Jane work there from this date to this date, and they're not here anymore, and they won't say anything more about it. Or you can negotiate things like a list of individuals that they're willing to provide references. And sometimes you've built up, relationships with people you trust, and that's something we're sometimes able to negotiate. Alternatively, when you're looking for non-disparagement provisions, an employer will resist putting in something that says ABC Corp and all its employees promise not to say anything bad about you or the individual, because how can they control what every single employee is going to say? That's going to be their position. So you can try to negotiate that in some way and say, well, all right, there's a list of individuals that I'd really like not to say anything about me. Some of the people maybe I had friction with. So these people, can we get a non-disparagement clause where these people are instructed not to say things about me or not to talk about me? You could also agree on a reference letter, which we've done on some occasions. All of these are up for negotiation. It depends on what kind of agreements you can come to with the employer on it, and what appetite there is for coming to some type of resolution and agreement here. Sometimes the relationship is very fraught and broken, and so it'll be very difficult to negotiate some of this. And that's just a fact by fact basis, case by case basis, I should say.
Seeing a lot of questions about non-disparagement coming through in the chat. So I think we've seen Beverly had mentioned that there are some clauses that say, we'll say only flattering things until the end of time. So narrowing the scope would be really useful, and making it mutual to the extent that that's supported by the relationship. I also got one confidential question that said, if you're being fired on the spot and asked to sign immediately, something including a non-disparagement clause, but possibly other paperwork as well, and you don't have time to get counsel to help, what options might you have?
Well, it depends on there are some people who are, the Older Worker Benefits Protection Act provides anyone over 40 with at least 21 days. And every employer knows it. That language is going to be in every separation agreement. And if it's not in there, I'm shocked. So you have 21 days, and they can't force you to sign anything. So you can't bring you in and sit you down and say, sign this if you want the 2 or 3 weeks we're offering you, or you get nothing. And that's it. And the reason that law was passed was because of exactly that situation. You had people who had been employed for decades. And so the employer, for whatever reason, is cutting labor costs or doing whatever they're doing, and they bring a bunch of people in and they say, here you go, we're going to give you a couple of months, sign it right now or it's off the table. And people are scared and they sign. And that's not right. And so the Older Workers Benefits Protection Act was passed to say, you've got to give these people 21 days. Oh, and by the way, they have 7 days to revoke it after that. And you've got to advise them to go get counsel and suggest that they do that. They don't have to get counsel, but you're advising them to go do it. And that's very important protections. For people under 40, there aren't any protections that are similar to that at this point yet. New York State is currently there's some law that may well be passed soon. It's right now in the Assembly. I think it's been passed by the Senate. That's going to provide 21 business days to anyone, which is a great law because it eliminates this whole issue of you being under the gun. I would say that if you're faced with that and you're not protected by a statute that gives you the time, that you just simply say, look, I need time to go review this with my attorney. They want you to sign the agreement very often because they want the general release or whatever else they're seeking under that. The non-disparagement clauses, there's value to that agreement to them. And you should have an opportunity to go seek counsel for it. And I would do my best not to be bullied. I would say, tell them you want time to see an attorney, get some reasonable amount of time, insist upon it. Ultimately, at the end of the day, if you're faced with that choice of this or nothing, then you have to make that choice. I think that probably, that's an unlikely scenario, but it could always happen. Until the law changes, unless you're over 40, you're not right now enjoying any specific statutory protections with regard to that.
So just to kind of close this out before we move to just question and answer from the audience, I think if you could leave everyone here with 1 or 2 concrete steps that they could take this month, even if their job feels stable, what would you recommend?
I think one of the most important things you should be doing, hopefully everybody's job is just great, right? But you should be mindful of what your rights are. And so familiarize yourself with the corporate policy. So familiarize yourself with the employee handbook. Know what your rights are with regard to all of these things. Refresh your recollection with employment agreements. What have you signed? What are you bound by now? Those things are critical to know, especially as these things develop in the future. So that I think is one of the most important things anybody can do in this situation is to know what your rights are in these instances. You don't necessarily even have to go see counsel for that. You just need to do the research on your own, see what your rights are. The other thing I suppose this is if nothing's going wrong, that's I think what probably the most important thing to do. With the issue is when stuff starts to go wrong, I suppose, and then you want to start thinking about documenting, taking those notes, being prepared to tell the story of what's going on, because that's my first meetings with everyone that I meet. It's all about that story. It's like, tell me the story of what's happening, and there's a lot of back and forth and chatting, and as the meeting progresses, that consultation, people's recollections get refreshed, and sometimes it takes they'll hire us, and we'll have subsequent meetings where things start to come up more and more. And that is very natural because you're going to start to examine what happened, and you'll realize that this happened and that happened, and you'll remember things. Help yourself out with those notes. Take those notes. This is when things start to feel a little different. Trust your gut. Start taking the notes. You'll have it for that story that you're going to need to tell someday. And maybe you'll find you won't need to tell it. And those notes will help you determine that.
Yes, absolutely. And I think my takeaway is meet an employment counsel lawyer before it's, really kind of the moment where you have to make a decision. If you're starting to have a gut feeling or you're starting to wonder what's going to be around the corner, it's probably a good time to start having those conversations so that you can make decisions with a cool head and be best positioned for whatever's coming your way.
Yeah, I mean, getting counsel can be critical, and avail yourself of the opportunity to go in and have that. Usually it's an hour meeting, right? It's a short meeting where we spend an hour talking about what's going on, and we can start to make recommendations about what might be at play and what rights you might have. And many employees often feel a little reluctant, right? They feel like this makes the employer think that they're spoiling for a fight. And look, I think that that's probably overblown in a way. And what you need to do too is level the playing field, because I promise you, the employers got counsel. They have attorneys on their side that are helping them through this process. Many in good faith, trying to act in good faith, but they have the benefit of that. Level the playing field for yourself and feel comfortable going and talking to someone. Those conversations are confidential. You don't have to reveal it to anyone, and you're the boss. When you come in and see us, we give you advice. But ultimately, you make the decisions about what you want to do. You don't want to do anything? That's your decision. If you want our help and you want us to help you in some way, you bring us on and we work for you.
I'm so happy that we had all of this great information come through, and we've seen so many wonderful questions come through in the chat. So we're going to take a few moments from now until roughly the end of the session to address what's top of mind for you. And the first, theme that has come up has really been around negotiating severance as part of the employment agreement or as part of starting this arrangement. And I think, one question that people have is, what is the right level of seniority for that to even be a possibility to entertain? And then, how does that, what are the pros and cons of taking that approach?
So you're talking about negotiating severance into the initiating employment agreement. It's a great idea, right? Mm-hmm. If you can, and many employment agreements I see do not have that at all. It's fairly rare in my memory, but if you can get that done and you have the ability to get that in there, then yes, because it takes a lot of the guesswork out of this later on down the road. It's perfectly reasonable to bring up. I don't see any reason at all not to bring it up. The situation, I mean, we see far more separation agreements than we see employment agreements. A lot of people, I can think of one that we're reviewing even right now. This was signed some time ago. That person didn't necessarily get counsel when they signed it. A lot of people go in and they just sign the agreement and they're anxious to get started and they go forward. So if you have the opportunity when you get that you get that offer of employment and an agreement is presented to you, you should get some counsel and talk to the attorney about that. This is as with everything we've discussed today. Everything is fact specific, and you need to go to counsel, an attorney, see him or her, and get the advice on this issue. If you can negotiate that provision into your employment agreement, take the guesswork of the end of this out of it, that is a great idea, and we're happy to see it.
Absolutely. So assuming the person has enough leverage and they are able to have this conversation, that's great. Let's see. So now the next theme that has come up has been around NDAs and what are those looking like in the separation agreements? So this attendee has asked, can you explain the frequent requirement of signing a broad NDA as a requirement for severance? Is that negotiable?
Yes, everything is negotiable. So you're talking about a non-disclosure agreement, and I suppose the nature of that is this comes in the context of confidential business information, that kind of thing. Those clauses are going to find themselves in separation agreements almost universally. Many employers are going to seek, and reasonably from some perspectives, to protect confidential business information that they have that is, would be detrimental to the business if it got out. And that, is it negotiable? Yes, it is. It is negotiable. Again, it goes to the leverage you might have as to where you find that that ability to make the NDA less onerous than it might otherwise be for you, right? The employer is going to, of course, make that confidentiality provision as broad as it possibly can be. And you're going to look to try to narrow that. And that's a fact specific question. Really has a lot to do with why, what are you concerned about? And what is it, what the information is it that you don't want to be bound by this non-disclosure agreement, that you want to be able to use in some way? And again, we've had comes up often in terms of clients or relationships that have been built over years, and you want to somehow protect your ability to utilize and leverage those relationships without running afoul of this agreement. And that's key. And it's something that you have to try to negotiate with the employer. But again, it comes down to leverage. And that is a fact-specific question too. What kind of leverage do you have? If you have a lot of claims, if this is a separation that happens for a very bad reason, then your leverage goes up. And you can negotiate more for yourself in this instance. If there are other reasons where that's not in play, your leverage may go down. It really depends on the facts of this case, of any individual case, as to what leverage you have.
Mm-hmm. So this attendee had been wondering if the NDA might be viewed as silencing employees from bringing forth information about the company later. So it sounds like that could be a situation potentially of leverage where this, relates to the NDA, to the non-disparagement, to the release of claims, and kind of the broader context. But that's my read as an outsider. Please tell me your expertise.
Well, I'm not sure exactly what they're referencing, but in general, if it's hard to prevent employees from reporting, misconduct through official channels, and public policy generally doesn't permit that. If you find yourself in that position, again, the first bit of advice, it seems like a broken record of sorts, but go see an attorney. And if something you think something is worth reporting to some authority, that there's some sort of misconduct or violation occurring, go seek some counsel right away and get some advice as to exactly what and how you proceed and how what you're bound by and what the ramifications might be. Again, fact-specific question, but that's extraordinarily important. You do have rights to make reports, but get some counsel on it. Get some help. Always get some help.
Yeah, don't try to DIY this. We have one question in the chat now. If you are laid off as part of a RIF, is the employer required to share information on the number of employees in the RIF and their positions, their job titles, etc.?
It depends on they can be. It depends on how the RIF occurs and how many people are involved in the RIF. So yes, there are state statutes and federal statutes that require information with regard to age and other and some other information perhaps in the various RIFs. But it depends on the size of the RIF. So it's hard to answer that question in the abstract. But there are instances where yes, an employer can be required to provide that information.
Right, and this seems like the kind of information that if you think it's relevant could definitely help with your case, and I think an attorney could help you get this information from the employer if you haven't been able to receive it already. The next question that I have, and we have a lot of questions actually that have been coming through in DMs, so we may not be able to get to all of them. I'm going to do my best. This is somebody who received a severance offer in a separation agreement and said that the RSUs that were included in the employment offer as a sign-on bonus have been forfeited. The contract is silent on what happens to the RSUs. Are there circumstances where somebody would have leverage to get unvested RSUs?
So if something's unvested, then it's hard to answer this question in the abstract too. I don't know exactly what the nature of the agreement is. I
Have you ever, have any circumstances come up where anyone has managed to get unvested RSUs?
I can't say that I faced the issue,
Mm-hmm.
so I don't know. Um, by and large, if something's unvested and you don't have, so the labor law isn't requiring that to be paid as remuneration or wages, it's going to be harder to, force that to be part of the agreement. That comes down to your leverage. We have, in terms of discretionary bonuses, that's often something that comes up, and employees want the bonus that they would otherwise have, but it's deemed to be purely discretionary. You're negotiating it with the employer. One thing you have to make sure of is it truly discretionary? Look, what's the policy? And how have these bonuses been paid in the past? And so these sound like they're subject to some specific agreement. That sounds like something someone's referring to that's subject to a specific agreement. And it really is bound by the terms of that agreement, what you're going to be able to negotiate. You can negotiate, again, you can negotiate anything. The question is, what's your leverage to get it?
Thank you. Um, One more question on a different angle. This is an individual who had an initial contract with an employer that stipulated what their severance would be. It would be a certain number of months, and there was a non-compete that both had agreed to. And then the termination happened verbally, and the exit date was also agreed upon verbally, and no additional paperwork was provided. This person is asking what paperwork should they get from the employer, and the answer may well be just get a lawyer, and they will tell you. But uh,
This
yeah,
is a very specific question,
yeah,
and so we're getting towards the possibility of actually giving legal advice, which would be utterly irresponsible in this
yeah.
instance. Again, everybody, this is for informational purposes, and that's exactly the type of question. Go see a lawyer about that. Sit down with the lawyer, and see. You've got an agreement you're talking about that you may well be bound by. You need to have, and it sounds like you could use some help interpreting it, and that's exactly what you should do. Get yourself there right away.
Fantastic. Um, okay, well, then I think that wraps it up for the questions that we have today. Thank you so much, Jim. Any final parting words that you'd like to share?
No, except to say that it was a pleasure speaking with everyone. I know this can be a difficult topic often because it represents the end of what's often been a long-standing relationship with people. So it can be a very difficult time in people's lives. And, we're happy to be able to assist in any way we can when people come in and make it a little easier, hopefully.
Amazing. Well, thank you so much, Jim, for sharing your expertise with us. Kathy, thank you very much for proposing this webinar. I think it's been really useful. I've learned a lot, and I'm sure everybody here has. And I've had a blast being here. And Deborah, HBS WANY, thank you again for having us. This has been wonderful.
Thank you so much, both of you. This was so informative. And as you could see from a lot of the questions, there's things that we often don't think about until a situation happens. So it's a great thing to think ahead about. So thank you very, very much for your time. It was great.
All right. Well, thank you all.
And we look forward to seeing all of you at the next event. We still have a couple of events coming up in December, and of course, a whole slew of things in January. So happy holidays to everyone, too. Bye bye.
Happy holidays.